Good morning, students. In last class, we have discussed the principle of rule of law as given by Dicey. In today's class, we shall discuss rule of law under Constitution of India and how the rule of law is applicable under Indian jurisdiction. When we talk about Dicey's rule of law, we say that it has been adopted and incorporated in the Constitution of India. The preamble itself has given the idea of justice, liberty, equality. Part 3 of the Constitution also discusses the concepts such as fundamental rights that are enforceable. The Constitution is supreme, and all the three organs of government, that is, legislature, executive, and judiciary, are subordinate to and have to act in accordance with the provisions of the Constitution. The principle of rule of law is also enshrined under Article 13 of the Constitution that states that all rules, regulations, ordinances, bylaws, notification, customs, and usages are law within the meaning of Article 13 of the Constitution. And if they are inconsistent with or contrary to any provisions thereof, they can be declared ultra vires by Supreme Court and by High Court. Further, we can say that the rule of law in India is upheld in the cases where president, judges of Supreme Court and High Court are required to take oath to preserve, protect, and defend the Constitution, where they say that no person shall be deprived of his life or personal liberty except according to procedure established by law. These provisions clearly state that the rule of law is applicable in India. As already stated, even the executive and legislature have to exercise in accordance with the provisions of the Constitution. Government and public officials are also not above law. The maxim, the king can do no wrong, does not apply in India. To say there is equality before the law and equal protection of laws. Government and public authorities are also subjected to the jurisdiction of ordinary court of law, and for similar wrongs are to be tried and punished similarly. They are not immune from any legal process, nor in any provisions made regarding separate administrative courts and tribunals. From all these examples, it appears that the doctrine of rule of law is embodied in the Constitution of India and is treated as the basic structure of the Constitution. In order to further understand the application of rule of law in India, it is important to take up the cases that relates to the concept of rule of law. One of the case, that is ADM Jabalpur versus Shivkant Shukla, which is also famously known as habeas corpus case, is the best example where one can understand the application of rule of law in India. In the present case, the Supreme Court was confronted with the question whether the third limb of Dicey's doctrine was an integral part of Indian concept of rule of law. The third limb that talked about predominance of legal spirit was taken up in order to discuss whether this limb of Dicey is important to consider under the Indian concept. In short, without getting into the details of the fact, the case is all about the proclamations that were made by Mrs. Indira Gandhi. In 1975, emergency was proclaimed by Mrs. Indira Gandhi on account of internal disturbance by virtue of Article 358 of the Constitution. The citizens' 7 classic freedoms under Article 19 stood automatically suspended. The President of India issued an order under Article 359 suspending the enforcement of Article 14, 21, and 22 also. Thereafter, a large number of persons were detained, not even informed of the grounds of their detention. Some of them filed writ petition in different high courts, thus challenging the detention orders as illegal and unconstitutional and praying for the issue of a writ of habeas corpus. In the present case, an attempt was made to challenge these detention orders during the emergency on the ground that it violates the principle of rule of law, as the obligation to act in accordance with the rule of law is a central feature of our constitutional system and is a basic feature of the Constitution. Without getting into the further details of the Act, I would like to state here that in the present case, the contentions did not succeed, and some justices even went on to suggest that during an emergency, the emergency provision themselves constitute the rule of law. Yet, if the reasoning of all the five opinions are closely read, it becomes clear that the contention was accepted. No matter, it did not reflect in the final order passed by the court. Therefore, even in spite of the unfortunate order to the effect that the doors of the court during an emergency are completely shut for detainees, it is gratifying to note that the concept of rule of law can be used as a legal concept. To put it in simple words, it may be stated that the narrow issue before the Supreme Court, before the constitutional bench of five judges that consisted of Chief Justice Ray, Justice Khanna, Justice Beck, Justice Chandrachud, Justice Bhagwati, was whether there was any rule of law in India apart from and irrespective of Article 21 of the Constitution. The majority of the bench, Justice Ray, Justice Beck, Chandrachud, and Justice Bhagwati, answered the issue in the negative and observed that the Constitution is the mandate. The Constitution is the rule of law. There cannot be any rule of law other than that the constitutional rule of law. There cannot be any pre-constitution or post-constitution rule of law which can run counter to the rule of law embodied in Constitution. Nor can there be any invocation to any rule of law to nullify the constitutional provisions during the time of emergency. And thus stated that Article 21 incorporates an essential aspect of that principle and make it part of fundamental rights guaranteed under Part 3 of the Constitution. It does not, however, follow from the above that Article 21 had not been drafted and inserted in Part 3 in that event. It would have been permissible for the state to deprive a person of his life or liberty without the authority of case. In the present case, the minority view of Justice Khanna was considered to be correct, sound, and consonance with the law. It was also submitted by many that the majority judgment in habeas corpus case is clearly erroneous, unjust, and contrary to the rule of law. And thus it is believed that in the case, the majority decision failed to consider in its proper perspective the most important fact that Article 21 did not confer a right to life or personal liberty. In fact, the said right inheres in the body of every living person, and Article 21, for that purpose, any written constitution is not the sole repository of the right to life and personal liberty. And as such, that right can never be taken away by the executive. However, it is pertinent to mention here that after 44th Amendment of the Constitution, right to life and liberty cannot be taken away even by the executive during emergency. But the case was a good example where one can say that the rule of law was not upheld by the court by taking into consideration that Article 21 can be taken away during emergency. Other cases that we can refer here in order to understand the observation of court with respect to rule of law are Keshananda Bharti versus State of Kerala and Indira Gandhi versus Raj Narayan. It is not important to get into the details and facts of the case, and thus I shall focus only on the observation as made. In Keshavananda Bharti case, the judges observed that the rule was considered as an aspect of the doctrine of basic structure of the Constitution, which even the preliminary power of the Parliament cannot reach to amend. Another case where Supreme Court has taken up the concept of rule of law is in Indira Gandhi versus Raj Narayan, where Supreme Court invalidated Clause 4 of Article 329A that was inserted in the Constitution by 39th Amendment Act 1975, wherein it was for the purpose of immunizing the election dispute to the office of Prime Minister from any kind of judicial review. In this case, Justice Khanna and Justice Chandrachud held that article violate the concept of basic structure and thus also offended the principle of rule of law. Thus, from these cases, we can say that the concept of rule of law has evolved under Indian jurisdiction over the period of time. and has taken a very positive position under Indian Constitution. With this, I would like to conclude that the principle of rule of law is a basic structure of the Constitution and is one of the important feature that regulates and governs the Indian legal system even today. With this, I end my second part of rule of law. Thank you very much. Have a nice day, all of you. Take care.